Good morning. So, our topic for today is about business organization. So, first and foremost, you have to choose the form of business organization you want to establish for your business. Would you like to be a lone owner, or would you like to invite one or more partners, or would you like to form a corporation? Before you choose, understand the following description, advantages, and disadvantages of each form. Let's talk about a single or sole proprietorship. So, by the way, there are three forms of business organization. So, the first one is single. So, when you say single, this business is owned by one person. If you are the owner, you are also known as the proprietor. You also exclusively enjoy all the earnings and suffer all the losses incurred by the firm. Because of this, any gain or loss of the business becomes personal in nature. Although you may seek advice from your friends, you are the one who will ultimately make and enforce decision. So, in short, a single ownership, no sharing of profit and loss, one man's capital, unlimited liability, less legal formalities, and one man control. That is for a single or sole proprietorship. Next is a partnership. So in partnership, this is more complicated than in a single proprietorship. It is a business owned by two or more persons who call themselves partners. In Article 1767 of the New Civil Code, a partnership is defined as a contract whereby two or more persons bind themselves to contribute money, property, or industry into a common fund with the intention of dividing profits among themselves. So all the partners share in the earnings, loses, and in the decision making process. A partnership may be created through oral or written agreement. So an oral agreement usually takes place if the partnership period is of short duration, let us say during Christmas time or Valentine season. However, though the partnership is oral in nature, an informal written agreement is suggested as a basis for reference and to avoid future conflicts. So the features of the partnership is joint decision making, risk bearing, continuity is ensured, mutual agency, minimum members required into two, maximum members in banking 10, maximum members in other business 10. Next, let's talk about corporation. So it is the most complicated of all forms. So it is a business owned by five or more persons who call themselves stockholders or members. As stated in Section 2 of the Corporation Code, it is defined as an artificial being created by operation of law, having the right of succession and the power, attributes, and properties expressly authorized by law or incident to its existence. So corporations are classified into stock or non-stock. So stock corporations issue either preferred or common stocks to its investors. On the other hand, non-stock corporations do not have capital stocks, but membership contributions. Preferred stockholders have priority over the common stocks in terms of dividend distribution since they will receive the dividends or what we call earnings of the investors are as a percentage of their investment. So ahead of common stockholders. So this is a corporation. So it is chartered by state. Many have subsidiaries. Many operate in several different businesses. It is separate legal entity from its owner. In like for example in UK, it can mean a state-owned company. It operates apart from its owner. So this is a company often with a board of directors. So let's compare single partnership and corporation. So from the preceding definition of sole proprietorship, partnership, and corporation, so this is the summary which I provided as a means of comparison. So for the number of owners, there is only one owner in sole proprietorship, while there are at least two partners in partnership, and a minimum of five is required in corporation. For the name of owners, the sole owner is called a proprietor or owner. In a partnership, an owner is called a partner. In corporation, the owners are referred to as stockholders or shareholders. If they have capital stock investment, stock corporations, or members if they belong to a non-stock corporation. Legal requirements, the corporation is the most difficult to organize. In applying for a business name, the sole owner accomplishes an application form with the Department of Trade and Industry. In partnership, the article of co-partnership are submitted to the Securities of Exchange Commission. According to Article 16670 and 1772, a written contract is required if the partnership capital is 3,000 or more, or when immovable um, property or real rights are contributed. So example of immovable properties are real properties such as land, machineries, furnitures, and other fixed assets. So in incorporation, the article of incorporation and the bylaws are submitted to Securities and Exchange Commission. The articles of the incorporation enumerate the general information about the firm, while the bylaws contain provisions for the internal administration, of the corporation. So the articles of incorporation usually include the following information: so the name of the firm, purposes, address, term of existence, information about the incorporators and directors, and data on capital stocks. So the bylaws normally include information about the manner of conducting meetings, authorities, and duties of the directors. So in terms of office, election procedures, and other specific procedures. So to be able to operate, all businesses have to secure certain permits, specifically um, the mayor's permit, permits from the Bureau of Internal Revenue, or what called BIR, Social Security System SSSS, Home Development Fund HDMF, and other government agencies. For the participation in decision making, so obviously the sole owner of single proprietorship has to make all the decisions. So in partnership, all the partners um, participates in major decisions, while in corporations, it is a board of directors of the board of trustees that makes decisions. In corporation, the number of board of directors should be not less than five, but not more than 15. So a board member should be a corporator too. Next, main proof of capitalization. So in a sole proprietorship and partnership, it is enough that their investment are recorded in the firm books. Usually, these are supported by official receipts or memoranda acknowledging their investment. So, in addition to the official receipt and registration in the stockholder subscriber ledger, a stock certificate is issued by the corporation. Next, we have the liability of the owner towards the firm creditor. So when the firm files a bankruptcy, the sole proprietor and the general partners have unlimited liabilities which extend to their personal assets. So, however, limited partners in a partnership and the stockholders of the corporation have a limited liability towards the firm's creditors. Their liability will only be up to the extent of their outstanding capitalization in the firm. Next, the source of capital or the source of income. So the capital of the sole proprietorship is limited since there is only one owner who makes the investment. So in partnership, the capital is wider since there are more than one owner. So by pooling their resources, they could raise a bigger sum than that of a sole of individual. So however, a corporation could raise the biggest capital investment since there are more than five owners who can pool um, their resources. So furthermore, a corporation can easily issue additional capital stock to be able to increase its capital investment. So aside from increasing its capital stock, it can also issue bond certificates to the public. Next, we have the income tax rate. So the net income of the sole proprietorship firm is not taxable since the income will form part of the income of the owner, who is taxed as an individual. So the net income of the partnership or incorporation is taxable at 33%. So furthermore, the partners and the stockholders are taxed individually for the income they will receive from their investment. For life, by nature, a sole proprietorship and partnership have the same life. In contrast to the corporation, both can easily be dissolved or closed. In a sole proprietorship, the owner makes a judgment whether he would like to close the business or not. He can choose the period wherein or within which the business would be closed. So while a partnership can still be dissolved by an actions of any partner, so the partners may agree on the date of dissolution. Because it is a contract, the term may be even be longer or shorter than 50 years. Other causes which may result in the dissolution of a partnership are the following: death of the partner, withdrawal, insolvency, incapacity, retirement, um, admission of the new partner, incorporation of the partnership, and when the government demands its closure. Then, for the corporation, cannot be easily dissolved, even with the existence of the factors causing partnership dissolution. So it will be dissolved when the board of directors decides to close the business or if a court orders its closure as an artificial being. So its life in 50 years, which can always be renewed after its expiration date. Okay, now let's talk about branding or making a logo or tagline. So this is very important in an enterprise or in a business. Okay, so first, branding is a marketing practice of creating name, symbol, or design that identifies and differentiates product service from that of the competitors. So it is also a promise to your customers. It tells them what they can expect from your product, service, and it differentiates your offerings from other competitors. So your brand is derived from who you are, who you want to be, and who people perceive you to be. So branding is one of the most important aspects of any business. So an effective brand strategy gives you a major edge in increasingly competitive markets. So the features of the good product brand are as follows. Number one, delivers the message clearly. Number two, confirms your credibility. Three, connects your target prospects emotionally. Four, motivates the buyer. And five, concretizes user loyalty. So here are some simple tips to publicize your brand. Develop a tagline. So write a meaningful, unforgettable, and easy to remember statement that captures the essence of your brand. Design a great logo. So create a logo suitable to your business and consistent with your tagline and advertise it. Write down your brand messaging. So select key messages you want to communicate about your brand. Be true to your brand, deliver your brand promise. And last, of course, be consistent, be reliable and consistent every time. So that's the end of our topic for today. Thank you.